And looks like the recording has started. So thank you everybody for being here. Again, my name's Mike Carmody. I'm the principal broker at the KW South Valley office. And tonight we want to go through the exclusive buyer broker agreement, and time permitting, we'll take a look at the exclusive right to sell. So how I'd like to do this as for perpetuity, we're going to be recording this class. So to try to keep it as organized as possible, I'm going to go through pretty much like section by section on this. So if you could kind of hold some questions until I got through each section, and and then we'll take a minute, see if there's any questions on that. Otherwise, I'm going to just kind of keep moving forward, and I'm going to give you some thoughts and suggestions and best practices, if you will, based on how I have used this document for almost 30 years now. As we have had buyer broker for, I've been told, about 35 years, and we've recently had a little bit of a change to this document, though not very much. So when meeting with a buyer for the first time, one of the practice changes now, before we go show any houses, we have to have an agreement in place. And that agreement, based on the settlement, has to have certain things in it, duration, the scope of work, and probably most importantly, any fee or payment that we as a buyer broker expect to collect, that has to be designated in some type of written agreement. Okay, so the Utah Association of Realtors, and at least at my brokerage here, KW South Valley, the document we have that satisfies that is this exclusive buyer broker agreement. And so let's take a look at the very top. One thing that I do read to my clients, if they're signing this in person, or if I've sent them a copy for electronic signatures, I still am going to take the time to go through it. I know electronic signatures are great and super easy. I will a lot of times send them a PDF of the document before I send it for them to just sign, right? Because fiduciary duties. I've got to take reasonable care with my clients to make sure they understand what they're signing. So I just tell them it is a legally binding agreement, and that if they have any questions, they could always consult an attorney. And then I just launch into my presentation with the document, if you will. And the first part, exclusive buyer broker agreement and agency disclosure between KW South Valley Keller Williams, which is the company or listing brokerage, myself as the agent, and I want to make sure that I have the buyer's names correctly. If there's more than one, sometimes there's three. Most of the time it's either one or two, but I'll usually ask them for their legal spelling in that document, for how they legally spell their name, or if they use a middle initial. And so I'll make sure that I get that as accurate as possible here on this document. And if they're not quite sure how they want to sign or what their legal signature is, okay, I'm going to get them to go through this document and sign it. And before we write an offer, I'll verify with them and the mortgage lender exactly how they want their name on title. So the term of the agreement, duration, right? Okay, we've got that in there. They retain the company and buyer's agent to locate and negotiate for the acquisition of a property for the agreed upon duration. Now they changed this from basically an expiration date to an end date. And you can do that for whatever time frame you want. I typically do them for a 6-month time period, because it can take a while, depending on the buyer, on how, if they're ready to go right away, if it could be a little bit of time. But I want them to have an adequate time frame to be able to find the right property, and I want a commitment from them for as long as reasonably possible. With the new rules, you could do this for a day. You could do it for just a couple hours. Okay. And there may be some times where people don't want to sign a long-term agreement, but they just want to see a particular house. And you could do this for, like I said, a couple hours, or even you could do it for years, right? And then in section 1.2, properties or locations the company represents the buyers. They've made some changes to this where they've given us a little bit kind of an or located within, say, a particular county, Salt Lake County, Utah County, Tooele County, or located at a particular address. So they do give us some flexibility if we have a buyer that just, wants to use our services in a particular neighborhood, then fair go. We can do that. So we can add addresses to it, get real specific. Again, I'm probably going to recommend that have a good conversation on your value with buyers to do a reasonable term, which in my opinion is probably 4 to 6 months, and for all the properties in a particular county that they're interested in looking. All right. And then this is kind of a new section on here. Unless checked below, the buyer warrants and that the buyer has not entered into a representation agreement with another brokerage and has no obligation to pay a commission to any other company arising out of the acquisition of a property identified in section 1.2. So we need to have that conversation with the buyer and ask them, have they entered into an exclusive agency agreement with another agent? And if so, is it property specific, or what are the terms of that, right? So based on these new rules, I think it's reasonable to assume that some buyers may just sign one of these with an agent to go look at 1 or 2 properties. So it behooves us to have that conversation with them now to make sure that, we're asking this question: have you entered into a representation agreement with any other agent or brokerage? And if so, they can check down here in this section where they could check that and say they have a representation agreement for, let's just say they were looking in Washington County, down in St. George. Okay, fair go. I'm going to help them up here. And now I'm aware that they have a representation agreement for an agent in St. George. End of this paragraph here in section 1, during the initial term and any extension, the buyer agrees not to enter into another buyer broker agreement with a real estate agent brokerage that conflicts with this. So if I go back to section 1.2, I'm going to help them in Salt Lake, Utah, and Davis County. Okay. They agree not to enter into an exclusive relationship with another agent in those particular counties. Okay. Pretty easy, right? Any questions on that part? Okay, let's move to section 2, brokerage fee. 2.1, buyer's obligation to pay a brokerage fee. If during the initial term or any extension of the term, the buyer or any other person acting in the buyer's behalf acquires an interest in any real property, as referenced above, let's again say those Salt Lake, Davis, and Utah County, the buyer agrees to pay the company a brokerage fee in the amount of, you got a dollar amount and a percentage of the gross acquisition price of the property. Now you can see they've highlighted the word buyer agrees to pay. Okay, little bit of a change, and it's always been that way with our buyer broker. At least during the time that I've been doing real estate, the buyer has always really ultimately been responsible for paying that fee. Up until August 14th, when we had the BBC buyer broker commission on the multiple listing service, okay, we could explain to the buyer that, technically we get paid by the listing brokerage. And usually there was always something offered there. Okay. Past few years, we've seen that number drop, but usually, I'd say most of the time, that fee that was being offered by the listing brokerage on the multiple listing service was a guarantee that we were going to get that fee paid from the listing brokerage to satisfy the buyer's obligation to pay, right? So I think that's still really the same. We just have to go about it a different way. But ultimately, we need to explain to the buyer that ultimately it is really them that is on the hook to pay us, right? The buyer agrees to pay. And then I'm going to explain to them and say, well, okay, we still have this satisfaction over a brokerage fee by a third party. If the seller's brokerage or the property owner, right? Because the property owner can do it now directly in our new real estate purchase contract. If the brokerage or property owner is compensating the company on a property acquired by the buyer, then the compensation paid to the company by the seller's brokerage and or the property owner shall satisfy the buyer's obligation to pay whatever brokerage fee we have in 2.1. Provided it's equal to, right? So let's say I charge a transaction fee of $499 and I choose to charge 3%. In section 2.1, I'm going to put $499 and 3% of the gross acquisition price. We go out, we make an offer on a property and we put in the offer to pay 3%, but the seller only agrees to pay 2%, then it's up to you as the agent to have that discussion with the buyer if you want to collect that extra 1%, right? As a broker, I'm not going to go after people and collect that extra money unless the agent instructs me to. Okay, so here at South Valley, I'm leaving it up to the agent. If they're willing to take less, then so be it. But if they want to collect extra money from the buyer, then that is up to the agent to have that discussion with the buyer, and then we can move forward from there. Okay. In section 2.3, brokerage fee due and payable, basically think of this, it's due and payable upon closing. Okay. When the property closes, whether it's being paid by the listing brokerage, the seller, or the buyer, we have guys like Marcel here with Real Advantage Title. They draft up the settlement statements and make sure that the money is getting collected from the appropriate person and paid to the buyer's brokerage. The end of that fee, section 2.3, brokerage fees are fully negotiable and not set by law or any board or association of realtors, multiple listing service, or any manner done in between the company and the buyer. It's always been that way. We've always had similar verbiage in these contracts over the years, guys, but that's part of this settlement, is making sure that's bold-faced. And we do need to let our clients know that commissions have always been negotiable. They will always be negotiable. And we have a duty to explain that to our clients, okay? Any questions on section 2? Okay, section 3, protection period. Okay, this is, personal preference, but the way I explain this to my sellers, I usually do 1 month, and I tell the buyer, say, hey, within a month after the termination of this agreement, if you purchase, exchange, obtain an option to, or lease any property that I located and actually physically showed you, then you would still owe me a commission on that property. Unless this last sentence, unless the buyer is obligated to pay a brokerage fee on such acquisition to another brokerage based on another buyer broker agreement entered into after the expiration or termination of this document. Okay, so there is a caveat to that. You just need to explain that to them. And honestly, over the years, I've never had any issue with that. Section 4, buyer representations and disclosures. Okay, this is where the buyer gives some warranties that the buyer will, in Section A, in all communications with other real estate agents, notify the agents in advance that the buyer has entered into an exclusive buyer broker with me. So I have the conversation with my buyer. Here's some of the things that will come up if you go to an open house. I want you to make sure that you need to let the listing agent there or the builder's agent at the open house know that you have an exclusive buyer broker with me. Also, furnish the buyer's agent with relevant personal and financial information. Obviously, we need to be able to get information from them to help them acquire a property. And C, exercise care and diligence in evaluating the physical and legal condition of the property that they select, right? In other words, I really want them to get a home inspection, and we're going to continue to talk about that when we find the right house. In D, they agree to hold harmless the brokerage or company and the buyer's agent against any claims as a result of injuries while inspecting a property. And E, upon signing the exclusive buyer broker, to personally review and sign the buyer due diligence checklist form and wire fraud disclosure. So guys, as a note here, when you're having your meeting with a buyer, these other 2 documents you need to have with you, the buyer due diligence checklist form and the wire fraud, right? Because it says upon signing this exclusive buyer broker agreement, they need to review and sign the buyer due diligence checklist form and wire fraud alert disclosure. At our brokerage at South Valley, we also have an affiliated business agreement disclosure for our brokerage that is required to be signed by the buyer. And also, great idea, check with your broker of what's required for your office. But here at South Valley, we also have the For Your Protection, Get a Home Inspection document. It's a really nice document just explaining to buyers, especially first-time home buyers, the difference between an appraisal and a home inspection. So when I'm meeting with a buyer, of course, I'm having the exclusive buyer broker. I've printed out the buyer due diligence checklist, the wire fraud disclosure, and again, here at KW South Valley, the affiliated business disclosure and the For Your Protection, Get a Home Inspection document. And in F says to disclose to the buyer's agents all properties in which the buyer as of this date has an exclusive buyer broker agreement, is either negotiating to acquire, has a present interest in acquiring. So it's kind of doubling up, in my opinion, a little bit more, going back up to, section 1.2. If they have already signed a buyer broker, did they make an offer on a particular property? I just want to make sure that I don't have any conflict and they don't have any conflict when they sign a buyer broker with me. Okay. Questions on section 3 and 4? Okay. Section 5, agency relationships. I like to just read this to the buyer. Duties of a buyer's agent. This is what you're hiring me for. By signing this exclusive buyer broker agreement, you designate myself as the buyer's agent and the principal branch broker for the company as agents for you to locate properties, as referenced in section 1, for buyer's consideration and review. And they also need to understand they authorize myself as the buyer's agent or the broker to appoint another agent in the company to also represent the buyer in the event that the agent or broker will be unable to service the buyer. So if I go out of town and I have an agent covering me while I'm on vacation, and my buyer wants to continue to look at properties, I've gotten pre-written permission to be able to do that. Now, I need to follow up with them before I leave town and explain that to them, that they're going to be well taken care of. Okay. And as agents for the buyer agent and broker have fiduciary duties to the buyer that include loyalty, obedience, full disclosure, confidentiality, reasonable care, and any other duties required by law. I like to read that and discuss that with the buyer and let them know that that I have those duties. We call them fiduciary duties to them. I don't take this lightly, and that they should expect all of those duties from me. That's the benefit of them entering into an exclusive buyer broker with me, is because we have those duties. I'm not just a functionary just opening a door, right? I'm taking their best interest above mine through loyalty, obedience, et cetera, et cetera. In section 5.2, I will talk with them a little bit about limited agency, and if that came up, that it happened to be that they were interested in a property that I have listed, or ultimately I list during the time of our relationship. And I'll talk with them a little bit about that. A lot of times I'll just summarize it and say, we'll kind of cross that bridge if we get to it, but obviously they're going to know if I show them a listing that I think is of interest, that's my listing, that's of interest to them. I'm going to be talking with them a little bit more about before we go look at that property, and let them know, hey, I'm also the listing agent on this property. And if you ultimately are interested in it, I want you to understand that you as the buyer and the seller will have to allow me to become a limited agent who still has fiduciary duties to both, but some of those become limited, right? And then it says in here, for this reason, the limit agent is bound by a further duty of neutrality. Okay, I think that's a good thing to review with them, to let them know what being neutral does, that I can't disclose to either party information likely to weaken the bargaining position of the other. And for the most part, I think if you explain that properly, most people will be fine with limited agency. Okay, when in doubt, check with your broker. Section 6 is the professional advice section. Good to review it with them. A lot of times over the years, I don't know who I picked it up from, but I said in this, professional advice really is, if I can't answer a question for you, I'm going to direct you to the person that can. If you ask me about surveys, I'm going to direct you to a surveyor. If you ask me about home inspections, I'm going to direct you to a home inspector, right? There's certain things that we're in the business of marketing real estate, as it says in the first sentence, okay, where I'm not trained or licensed to provide them with professional advice regarding physical condition of the property. But we're always going to do my best, or I'm always going to do my best to direct them to professionals that can answer those questions, right? Get part of my fiduciary duties. In section 7, dispute resolution, you hear debates of, are you a shall or a may agent? I'm happy to say I'm a may agent. Parties agree that any dispute related to the exclusive buyer broker arising prior to or after the acquisition of a property shall or may. I like my folks to be able to just go get an attorney right away if they want to, and not first have to submit it to mediation. That's just my personal opinion. I'd recommend you, think about that, what you want to recommend. Mediation is not binding. I know some people want to go to mediation and you could be a shall, but ask your client what they want to do. And invariably, I find that they ask me which one I would choose. I'd say I'll keep my options open and check May. Okay. In Section 8, attorney's fees, governing law, class action waiver. We're seeing this class action thing in here. Typically, it used to be attorney's fees, and I would explain to folks that, if a dispute arose between you and a seller or through the company during this process, that the prevailing party can get their attorney's fees paid, and that's still the case. And now, when we're dealing with this last part of it, the buyer forfeits any and all rights to participate in any class action against the company. In particular, the buyer agrees not to be a representative or member of a class of claimants or act as a private attorney general in litigation, arbitration, etc. Okay, so that's new for this. And the way I'm explaining it to people, I find number one, they really don't care, but it's my job to go through this document with them and say, we've already been through a class action lawsuit. That's why there's settlement practice changes. And that's why we ask that you agree not to enter into any other class actions against the company. Okay, questions on 6, 7, or 8? All right, let's talk about buyer authorizations. So the buyer authorizes the company and the buyer's agents to A, disclose after closing the multiple listing service, final terms and sale price, right? We've always done that, but they're giving us permission to do that. And 9, B, to communicate with the buyer for the purpose of soliciting real estate goods and services during and after the term of the exclusive buyer broker. And I've had a client ask me, why is that? And it's the only good reason I could really give is just that in case they're on the do not call list. During the time that we're doing a transaction, it makes sense, but even afterwards. And if you do a good job, people don't mind you keeping in touch. Buyer further agrees in any transaction for the acquisition of property as referenced in second one, the earnest money deposit may be placed into an interest-bearing trust account with interest paid to the UAR, Housing Opportunity Fund, to create affordable housing. So just a disclosure to them. Okay, in Section 10, attachments, the buyer due diligence, and here they reference this again. So when we're getting this exclusive buyer broker agreement signed, this attachments to it inherently are the due diligence checklist and the wire fraud, right? So look at those 3 documents, all need to be sent at the same time. And again, in addition to here at KW South Valley, we have the affiliated business disclosure, which doesn't necessarily have to be signed at the same time as this, but it's just a good idea to get everything signed at once in what I call my buyer packet, my buyer paperwork. Okay. Now, if you don't have any other addendums, if you just have the buyer due diligence checklist and the wire fraud disclosure, and here at KW South Valley, the ABA, and the for your protection, get a home inspection. If you have those documents, you can check or not. There's no additional terms contained in an addendum. If you use an addendum to specify something on here, this is where you would check that. Now, if you check R, make sure that you have an addendum to this. Okay. One of the questions that I could say may come up, and I'm getting a lot of people ask now due to the new rules, can I do an addendum to the buyer broker that says something like this, Mike? And now I'm going to work on the assumption that in section 1.2, or excuse me, 2.1, that I put my transaction fee and 3% of the gross price is what I'm charging. Can I do an addendum to this in section 10 that says something to the effect that buyer's agent and broker agree that if the brokerage fee is less than 3%, whatever that amount is, that will be acceptable to the buyer's brokerage. I can speak for my agents at KW South Valley. We cannot do that. Okay, that is not allowed based on the terms of the settlement. It would be considered fraud, and we just don't want to go down that road. So kind of hard and fast rule here. It has to be an exact amount based on the settlement. It can't be open-ended. It can't be up to 3% or anything like that. It has to be an exact amount. Now, can I tell my client that I'm willing to work with them, pending on, the property they find, if we can't negotiate that full 3% fee to be paid? Sure, but we just can't put it in writing. or we're in violation of the settlement. Okay. Section 11 talks about that the buyer and the company would comply with federal, state, local fair housing laws, and that electronic transmission and counterparts, including faxes, emails, and though they don't specify it here, electronic signatures. Okay, they're all legal and are acceptable on these documents. Section 13, a due on sale. For a buyer, I don't get into this a whole lot, but they will ask about it. And I'll just say that, most properties that they're looking at, chances are that the seller is going to have a loan on that. And there's an extremely high probability that that loan has a due on sale clause on it. Okay. And that's going to need to get paid off. So fair go really doesn't affect the buyer. They're going to get clear title to it. But in the event that they choose to look into seller financing, or possibly even a lease option, there are times when that loan may not get paid off. So it's kind of a disclosure ahead of time to buyers. I don't really spend a lot of time with it unless this particular buyer is specifically looking for seller financing. I'm going to disclose over and over and over what a due on sale clause is, especially again for a buyer that's looking for seller financing. Okay. In section 14, here we are at the end of the document already. This exclusive buyer broker agreement, including the buyer due diligence checklist form, wire fraud disclosure, and any additional addendum, contain the entire agreement between the parties. So again, we're told that we have the exclusive buyer broker, but that needs to be coupled with the buyer due diligence checklist and the wire fraud alert disclosure at minimum. Okay. And then we're going to get signatures at the bottom from every person that's on it. If you put two names up here, let's just say it's John and Jane Doe in as the buyer, but only John Doe signs it, you do not have a legitimate contract. Okay, you got to have both signatures on it, and you need to have at the bottom it says accepted by the company's signature of authorized buyer's agent or broker. Okay, here at KW South Valley, I'm happy to sign them, but as an authorized buyer's agent, you can also sign that too to move forward with your paperwork. So guys, that in short, and I probably don't spend that much time with it. I'm kind of more hitting the highlights, but just depending on the buyer. If it's somebody I've worked with before, I'm going to probably not go into as much detail on it. First time home buyer, I'm going to spend a little more time going through this buyer broker document and talking about my value proposition. And a lot of that is focused on those fiduciary duties that, again, I'm not a functionary. We're entering into an agency agreement where I have by law fiduciary duties to them, right? And that means I'm putting their interest above mine. That's why they're hiring a real estate agent, somebody to look out for their best interest. Right. So that is the buyer broker form. We're about 4:30 on it. Do you guys have any questions on it? All right. You want to move over to the listing agreement? Give me 1 second here. All right. You ready to dive in on the exclusive right to sell, listing agreement, and agency disclosure? Conversation with potential clients when we're going to list their house. Again, legally binding agreement. Read carefully before signing. If you have any questions on it, you always have the right to consult an attorney. Okay. Exclusive right to sell listing agreement and agency disclosure. Again, it's a listing agreement and an agency disclosure, right? Entered into between, in this case, it's KW South Valley. Myself as the agent and the seller. Very important on the listing agreement, and Marcel touched on this a little bit at the beginning. When somebody calls me, or let's just say it's somebody that I've never worked with before, and they say they have a property to sell, and I was referred to them, and I'm going to set up a meeting on it. I'm going to do my due diligence and obviously get as much information from them as possible. One of the most important things on it is, okay, once I get the address for the property, I'm probably just going to pop right into the county records and look and see, is this property in a trust? Who is actually on title? And as Marcel can probably concur, I bug him, though I know I'm not bugging Marcel. sometimes the county records information that I see linked in here to the MLS doesn't give me all the names. It might get cut off. So usually if there's a question on it, I'm going to give Marcel a call, give him the address and say, hey, can you confirm, who's on title? And in this case, yep, Marcel confirmed that it is actually John and Jane Doe as joint tenants. Or if Marcel says, you know what, it looks like it's in the John and Jane Doe living trust, then I know I'm going to have a conversation with John and Jane to verify who are the trustees of that trust. Are they the legal signers of it, right? Um, so by asking those questions and when in doubt, push a little bit further. If I have John and Jane Doe and I'm talking to Jane and Jane's mentioned that, they're in the process of a divorce, it's going to give me a little bit of, it's going to throw up a red flag. I just want to make sure that I've got all the correct sellers on it. So I can take a legal listing and certainly make sure that before we end up going under contract. Okay, so as an agent, fiduciary duties of reasonable care, right? Make sure that you're verifying who is on title.
Hey, Mike.
Marcel, go ahead.
Yeah, sometimes the county records they don't have it, like their software doesn't allow the full name to go on there, so it can be kind of confusing.
Yep.
I was working with a new agent last week, and he was talking to a seller, and she was on title, but there's another person on title, and their name was actually, the county put their name first. And so he was going to do some more digging. So it could have been maybe a father who co-signed with her, or maybe a boyfriend or an ex-spouse. And so it just kind of gave him a little heads up to go into the situation and ask a few more questions, so we knew kind of what the story was, and made it a lot easier to ask those questions now than try to figure it out later.
Excellent. Great advice. Yep. Do a little digging on it, guys. Double check, we we need to do that. Last thing we want to do is enter into a listing agreement where, all of a sudden you get a phone call from, somebody that's on title saying, hey, why is my house on the market? Okay. As a broker, that really scares me. But it's really easy to get the right information. It's just maybe an extra phone call. And again, a plug to Marcel because he does a terrific job at it and is available. I know I can call him, verify that information, and make sure I have it. And when I go to set the appointment, that I've got all the decision makers there. If I don't want to meet with just, if I got a husband and wife, I need both of them to sign to have a legitimate listing agreement. Okay. So we have in term of listing, obviously that's the particular property, and now they call it an end date versus an expiration date. And me typically, if always 6 months. Okay, you can do more, you can do less. There's some flexibility there. Be careful doing a really short term, 30, 40 days, it's not a lot of time. So, use your own discretion there, but I think the lowest I think I've ever done is maybe 90 to 120 days, with some particular clients, but make sure you have enough time. If people say, why does it take 6 months? Well, typically it doesn't, but we can list a property be on the market for 30 days before we get an offer. Unfortunately, deals fail. We could be under contract for, another 30 days. So we're already 60 days into it, and that buyer loses their job and we got to start over. So I want that time built in, and most sellers will understand that. Okay, moving into section 2. Now, for those of you that have been just recently in the business, this probably doesn't seem a whole lot different. For those of us that have been practicing real estate for quite some time, it is a little different. Okay, the old listing agreement, we kind of we had this gross commission that was the seller's brokerage fee, and then we had lower in that paragraph an amount that we were authorized to share from that. Okay. Now they're breaking it out. Seller's brokerage fee. Okay. In section 2.1, seller's agent, seller, another real estate agent, locates a property, is ready, willing, and able, right? Those pretty much standard listing verbiage, if you will. The seller has negotiated with and agrees to pay the company a brokerage fee in the amount of X. So I have no problem telling my standard fee for a long time for me personally, not anyone else, because commissions are fully negotiable. They're not set by anybody, has been 6%. And I've always encouraged my sellers to allow me to share 3% of that out with another agent. Okay. It's worked great for a very, very long time. As of August 14th, it operates a little bit differently. Okay. And so now the way I explain it to my sellers, I say, well, in reality, I'm charging you 3% in section 2.1. And folks, I'm going to recommend and strongly suggest in section 2.2 that you allow me to offer up to 3% out to a buyer's brokerage to compensate the buyer's agent, like we've done for a very long time successfully. Okay. We do need to have the conversation with our sellers and let them know that they do not have to do that. Okay. And I need to tell my sellers they don't have to, they've never had to allow me to do that. But now my conversation is, folks, you don't have to. You don't have to offer out or give me authorization to offer that out on your behalf. I will tell you that if we don't offer it, I wouldn't be doing my job if I didn't tell you this, that you can expect that the buyer and buyer broker are probably going to ask you to pay for it in the offer, right? All of a sudden, this settlement is not just changing it to where sellers can expect to never pay a buyer broker again. It's just not the way it is. But I do need to give my client the option to do that. And me personally, it's okay for you personally to give your thoughts on that and your recommendations. Okay. Because I'm telling them brokerage fees are fully negotiable. They're not set by any law, board, or association. They never have been. They never will be. But nowadays, we cannot advertise the buyer brokerage fee on the multiple listing service. So if you don't offer that compensation, a buyer, not a buyer's agent, a buyer may choose not to look at your home because they frankly may not be able to afford their down payment, their closing cost, and the cost of their agent. So I'm having a little more, I'm having a different conversation with my sellers these days. And my experience over the past couple months that we've known about these changes is that they understand it. And in my experience, every one of my sellers has still agreed to allow me in section 2.2. The company is authorized to advertise or otherwise communicate that the seller and or the company is offering to pay compensation to a buyer's brokerage in the amount of up to X. So it can happen one of two ways. I can offer it out to Vicky, could call me. I'm the listing agent. Vicky's representing a buyer. Vicky says, are you offering compensation? I have it signed here. I have a legitimate listing agreement in place. And I say to Vicky, my seller's authorized me for up to 3%. And Vicky says, great, I have a buyer broker at 2.5%. I say, terrific, Vicky, if you'd like to send me over real estate brokerage compensation, escrow instructions, and you sign it, I will sign that, and you know you will get paid that 2.5%. And you don't need to put the brokerage fee in the offer. Okay, that's option one. Option two, Vicky calls me and I say, yes, we're offering up to 3. And Vicky says, great, I have a buyer broker for 3%. So that'll work great. And I'm just going to put it in the offer, Mike. And I say, terrific. Okay. And I'll wait for the offer. And I'll explain that to my seller when we get the offer. I'll do the net sheet and I'll show the seller that you're paying 3% to my brokerage. And in this case, inside of the offer, you'll be paying another 3% to the buyer's brokerage. Okay. In section 2.3, the compensation agreement between the company and the buyer's brokerage, in the event the company agrees in a written compensation agreement to pay a buyer's brokerage, the only document that can happen in is the real estate brokerage compensation agreement. I'm going to call it the escrow instruction. That's the form that Vicky sends over to me that she signs and I sign. That is a compensation agreement between the listing brokerage and the buyer brokerage. And that was option one that Vicky had on the example I gave you before, where she called and said, are you offering cooperative compensation? I said, yes, I'm authorized to offer up to 3%. And Vicky says, well, I have a buyer broker at 2%. Great. Send me over the brokerage compensation agreement, escrow instruction. And she does that. In that case, when I get the offer from Vicky's buyer, I have a copy of that form. I'll have my seller sign it and say, seller, 2.1 gets added to 2.2. So 3% for me, 2.5% for Vicky for a total of 5.5. Okay. I hope this gets a little bit confusing, but it's whether the commission is being dealt with from me as the listing agent, broker to broker, or is it inside the REPC where it is seller to buyer's broker. Okay. So in option 2, where Vicky says, hey, I got one that's up to 3%. Great. And she just puts it in the offer. That is the seller paying me 3%. And on my net sheet, I'm going to tell the seller, you will be paying. It has nothing to do with section 2.2 or 2.3. My fee is the 3% being paid, and Vicky's is the 3% being paid in the offer. Questions on that? Terrific. You guys have probably been getting this pounded into you for over the past month. So thank you for paying attention. Section 3, protection period. Okay. 1 month, whatever you're comfortable with, right? It's basically the same thing. I just tell folks, listen, if the listing expires, which you'll probably have fired me by that time, right? But if the listing expired and within, if I put 1 month here, somebody that I personally showed the home to came to you and wanted to buy it, you would still owe me a commission. And they're like, okay, that's fine. Section 4, seller warranties and disclosures. The way I explain this to sellers, I just flat out tell them the most important document that I think that a seller will sign in this whole transaction is the seller disclosure document. Okay. Because the only recourse a buyer has with a seller, again, in my humble opinion, after the property closes is if they can prove that a seller maliciously didn't disclose something. So I want to make sure that the sellers understand this seller disclosure document that I'm going to share with them. They need to really take that seriously and take their time, right? So section 4, seller warranties and disclosures. The seller warrants to the company that the individuals or entities listed as the seller are the owners of record of the property, right? We've already talked to Marcel, so we know we've got that. They also have marketable title to the property, right? Think short sale, right? Guys, if they owe 500,000 on it and the house is worth 400, I argue, do they have marketable title? They do. They just got to get lender approval. Okay. Seller agrees to furnish buyer with good marketable title and pay at settlement a policy of title insurance. So this gives me an opportunity to show them when I'm doing a net sheet that they're going to need to provide title insurance to the buyer. And middle of this paragraph in section 4, upon signing this listing agreement, seller agrees to personally complete and sign a UAR approved, the seller property condition disclosure form, and wire fraud. So like on the buyer broker, we had the buyer broker, the buyer due diligence, and the wire fraud. Here we have the exclusive right to sell, listing agreement and agency disclosure, and the seller property condition disclosure, and the wire fraud that kind of get all lumped together. Okay. Continues, seller agrees to indemnify and hold harmless seller's agent company against any claims that arise from A, the seller providing incorrect or accurate information regarding the property. B, the seller failing to disclose material information regarding the property, included but not limited to the condition of appliances, et cetera, et cetera. Okay. Guys, read through this because it'll jog people's memories. If you read about sewer problems, and they've owned the property for 30 years, they may have forgotten it. The whole house backed up with sewer and they put a new sewer line in. Okay. So by just kind of hitting the highlights of this document with your folks and encouraging to read it, it's beneficial, right? Some of these things may come up. Location of property lines, So we're talking about it here in this listing agreement. And then when they get to seller disclosures, it's another opportunity to jog their memory because my experience, people just forget. If they've been in a property for 10, 15, 20, 30 years, they just, they got to get their memory jogged a little bit to remember some of the things that have happened. Think about that yourself if you've been in a property. How would you do on your seller disclosures? Any extra reminders would be helpful. Section 5, agency relationship. Just like we talked in the buyer broker agreement, I like to talk with them about what are my duties of a seller's agent. Okay. Again, as the listing agent or seller's agent, a principal branch broker, we're agents for the seller, locate a buyer for the property. And they authorize me to appoint someone else. So think about me as a listing agent. If I ask another agent to host an open house for me, I've got permission from the seller to be able to do that, right? I'll talk with them about duties of a limited agent, just like I did with the buyer broker. Look, professional advice, right? Very similar to the buyer broker. Again, I just tell them, hey, I'll hit the highlights of this paragraph and just tell them, listen, professional advice. If you ask me a question I can't answer, I'm going to direct you to the people that can. If you want to know a lot more about radon, let me introduce you to a radon company that can talk with you more about radon. Okay, those type of things. Dispute resolution, not the first time we're seeing this tonight, whether you're shall or may. Again, just talk to them about if they check shall, that mediation, there's probably a nominal fee for mediation, but mediators cannot impose binding decisions. They can still get an attorney. Section 8, attorney's fees, again, if there's a dispute arose between them and a buyer, the prevailing party can get their attorney's fees paid. And again, that class action waiver, right? Class action that they forfeit all rights to participate. I think we need to be talking, this is new to this document. We need to be pointing that out to sellers because they've heard about this stuff. So let's educate them on the class action lawsuit that ended up being a settlement where we have some practice changes that, again, in Utah, really not not a whole lot has changed. Okay. Yeah, we lost the BBC on the MLS, and that's created a few issues and differences on how we have to negotiate our pay on behalf of our buyer. But the reality is we have had good listing agreements that disclose that we were offering cooperative compensation for as long as I've been selling real estate. And we've had buyer brokers where the buyer knew who was representing them and how we were getting paid. Okay, so hit that last section on there about that class action waiver they're signing. Section 9, advertising seller authorizations, and this is places where you can kind of hit your value proposition. I'll go through and say, sellers, you're giving me the ability to disclose on the MLS the final terms. And let me tell you how important and effective the multiple listing service is and what an awesome tool it is for sellers that anybody in the world, once we're on the MLS within 24 hours, man, we're worldwide distribution with that. MLS is a very powerful tool, always has been, always will be. You allowed to disclose the MLS to square footage and where are we obtaining that from? Little side note on this, guys, be accurate with this, okay? If you see on county records, I always start with county. What does county tell me? If county shows that I've got 2,000 square feet on a house, and then I look and see on the old MLS that, the house has been sold 5 times and the square footage is all over the place, or that it's like 2,400, I know I got a little bit of an issue. I can't rely on those. I don't like to type in here and say that I took it from an old MLS, right? And as a broker, I'm going to go with what I can kind of verify, and that's county records. So in those cases where there's a discrepancy between the old MLS and the county records, I'm going to ask my seller, do they have an appraisal? Have they had an appraisal done, and ask them to dig around? They may find it because that's probably the most accurate. If we've got a real big discrepancy, it's like, let's, call somebody and get it measured. Okay. So be accurate where you're taking that info from and use your due diligence. Again, I always say reasonable care because that's the easiest of me to remember when it comes to the fiduciary duties, but reasonable care. Did I look and see that the county record showed 3,000 square feet and all the old MLSs had 4,000? Did I use reasonable care for my seller to try to verify that? Okay. In section C, they're giving me permission to obtain financial information from any lender. Now, I tell them I don't do that. That's a job for my buddy Marcel. I'm going to say, Marcel, my title company is going to get in touch with you to get direct financial, get an authorization to get a payoff on your mortgage. Okay. I don't need to have that information. I certainly don't need your social security number. And so I'm going to ask my title company with some help for that. 9D, to have keys to the property, right? Permission to have keys to the property. Make sure you don't take their only keys. Make sure that they have a copy. Okay. In section 9, have an MLS or board. We use super key boxes, folks. These are secure key boxes. Only licensed agents, appraisers, and home inspectors can access these. We can set them to have even more security features. So it's a benefit of working with me as a real estate agent because I use a super key box, not just a contractor lockbox. Use these advertising and seller authorizations to bolster what you're going to do for your client to protect them. In F, we have permission to hold open houses. And G, have for sale signs. Talk about the signage that you're going to use. Are you going to use a QR code on it, right? So I hope you get my point that when you're going through this, talk to them about what this means to them and the benefits of using you and your type of signage, right? Also, to order a preliminary title report, order a home warranty if it's applicable when the offer, if it's up to the seller's agent to order the home warranty. And again, communicate with the seller for purposes of listing real estate goods during and after the term. And again, with the earnest money deposit, right? Section 10, personal property. I'll spend a little bit of time on this pending on the sale. If the property's vacant, maybe not so much, but I just tell folks, listen, as much as we can screen people coming through, meaning that we use a secure lockbox system that the general public cannot access. People can get in the house and we could possibly have some issues. So if you have cash, you have valuables, if you have firearms, if you have medications that are in high demand, and I'll chuckle with them a little bit, keep that stuff locked up. Okay. That they have some responsibility to make sure that that personal property is taken care of and that they hold us harmless for any loss or damage. Okay. Section 11 gives us attachments. If we have, again, we see that in section 11, what else do we have with the exclusive buyer broker? We got the seller property condition disclosure, the data form, which is the MLS data form, and the wire fraud disclosure. And if you're at KW South Valley, again, we're using the affiliated business. Okay. So all those documents become my seller packet. I want to have all that to get it done all at once. Section 12, FERPTA. Okay, if you do have a foreign person that owns real estate, when in doubt, Marcel again is a good resource to maybe help me investigate a little bit further whether somebody would be considered a foreign person, but you got a real big tax issue. So understand FERPTA. Sellers and buyers sign this like 5 or 6 times throughout all their documents on there. From a seller's perspective, we really want to know, are they considered a foreign person, which may include a non-resident alien, foreign corporation, foreign partnership, because we need to disclose that to the buyer. And ultimately, correct me if I'm wrong, Marcel, there's a big tax implication for everybody involved. Okay.
There could be, yes. Yep.
Yeah, thank you. 13, seen it, we comply with equal housing and local fair housing laws, electronic transmissions and counterparts, due on sale. I'm going to talk to my sellers about that, and most understand that they have an underlying mortgage that's going to be paid, that probably has a due on sale clause on it, but obviously it's going to be paid off for them to pass clear title to the property. Again, if you're getting into a seller that has an underlying mortgage and you're talking about seller financing, as a listing agent, and again, as a buyer's agent on it, go out of your way to disclose to all parties that there's probably a due on sale clause. Okay, because you could get into seller financing and the underlying note holder could call that loan due, and everybody needs to know how that's going to look. Okay, if you're not familiar with seller financing, go take a couple classes on it and get familiar. It's common, but not super common, right?
And always welcome to reach out to me to go over scenarios with that too.
Absolutely. And Marcel, thanks for being on here. Title, and I'll just say escrow officers, mortgage lenders, invaluable to us as real estate agents. I'm still learning from Marcel. I'm still learning from the mortgage lenders that I use, guys. You got to have a team. I have a team in place. Find your team and use them. Title and mortgage. Okay. Then we got some signatures on it. Again, same thing. If you've got John and Jane Doe and only Jane signs, you don't have a legitimate listing agreement until both signatures are on there. Questions? Guys are making this easy on me tonight. So
Mike, I have a question.
Go ahead, Vicky.
Yeah. So, all these new buyer agreement and seller agreement talking about transparency to the clients.
Mhm.
So, is this transparency also available for the agents? For example,
Give me an example.
yeah. So you just mentioned if I bring a buyer to you, like we made a deal,
Mhm.
and do you ask for the buyer agreement from me, or am I allowed to ask a copy of a seller agreement from you? Is this
Yeah,
a kind
great
of a
question.
transparency?
Yeah, great question. And I get their question on it. I'd say no, probably not. No, there's no guarantees of transparency. And I think where you're going with it, I know there are some listing agents
Mm-hmm.
that before they will enter into the compensation agreement, which again is outside of the contract, right? That's broker to broker, kind of the way it was always done,
Mm-hmm.
right? That they're saying, well, we're not going to do that until we have a copy of a buyer broker. You know what? If you're the buyer agent in that case, what am I going to do? I'm
Mm-hmm.
going to talk to my buyer about it. I'm going to ask my buyer and say, hey, as part of sending this offer and before they will sign anything and agree, they want to know what my buyer broker is for. How do you feel about that? Really, all I'm sharing with them is what I'm charging you. So
Mm-hmm.
I, as the agent, I'm not going to make that decision because I need to take that to my client. And my client may say, Mike, I don't care. Will this help me get the house? In that case, I'm going to share that information with the listing agent.
Okay.
As a listing agent, again, asking on the other side of it, asking you, me personally, I'm not going to do that because if I enter an agreement with you on the brokerage compensation
Mm-hmm.
and you and I signed it and we signed it at 3%. That's what my seller allowed me to. But
Mm-hmm.
your buyer broker is only 2.5%. Shame on you. I think you just had a violation of the code of ethics, and I think you just committed fraud.
Mm-hmm.
Now, can I police it? Not my job to police it, but I hope that your broker will catch that.
Yeah.
And as a listing agent, I'll probably ask the title company to,
Mm-hmm.
would they mind verifying that? Right. So we're getting a lot of this. Well, I'll show you mine if you show me yours. And it just depends. I think at the end of the day, whether you're a buyer's agent or the listing agent on it, us as agents don't set the policies and stuff on it. Our clients do. I'm going to talk to my client about it and say the listing broker is asking for confirmation. They want to make sure they're not paying too much. Buyer, here's the benefit, here's the drawback. What I will say that do not share an agreement. If you're a buyer's agent, do not share the buyer broker without
Mm-hmm.
permission from your buyer. Why? We have fiduciary duties of confidentiality. Okay, you could be
Mm-hmm.
violating your fiduciary duties. So when in doubt, have a conversation with your client, whether it be a seller or a buyer, to
Mm-hmm.
have open conversation. And that's really the best advice I can give on that, Vicky.
Okay, thank you.
Mm-hmm. Yep.
So, I have another example.
Sure.
If the listing agent asked me to host an open house for them, and they said, I'm going to offer you 2.5 compensation, am I allowed to tell my client that seller will pay for me and you don't have to pay for me, even we have an agreement with these, like a
Okay, so
contract?
let me make sure I got it. So again,
Mm-hmm.
you're hosting an open house, and the caveat to that, as long as it's with an agent within your brokerage, in this case, KW South Valley, you cannot hold an open house for somebody outside of the broker.
Yes, right.
And if the listing agent, so as you're hosting that open house, you are
Mm-hmm.
technically an agent, you're representing the seller.
Mm-hmm.
Okay. So if I'm hosting, you're the listing agent, Vicky, and I'm hosting the open house for you.
Mm-hmm.
I'm going to ask and say, Vicky, as your seller, are you authorized to offer a buyer broker on this? And
Yes,
if
we
you tell
do.
me, yes, the seller
Mm-hmm.
has authorized me to offer up to 2.5%
Mm-hmm.
as an agent within the same brokerage with permission from the listing agent, I feel
Mm-hmm.
it's okay for you to, if an agent walks into that open house, that you could tell them that the seller is offering 2.5%. I don't see
Mm-hmm.
a problem with that. I think the better answer would be, before I say anything, this is not my listing. I'm hosting this on behalf of the listing agent. I'd ask you to call the listing agent if you have that question. Better
Yeah,
safe than sorry.
yeah,
Okay. Yeah.
great. Thank you.
Mhm. So I'm not sure. I think I only see, it looks like Jake, just Jake and Vicky. Jake, any questions on your end regarding these two agency documents?
None here. I've been going to the Friday trainings with the broker to get that drilled into my head for most of the document changes.
Good deal. Good deal. Now that's great. And I appreciate you guys giving me the time to go through these documents. Again, just keep reading them, guys. Every time you read them, you learn something and you learn a better way to communicate it to your client. You owe them that duty to don't have to read it line by line. You can if you want, but you need to have a good understanding of it. And if you can't explain it, you probably don't understand it that great. So if you can explain it easily to your client, then I'd say you have a good understanding of it. So keep up the good work. I will let you guys go and let's go sell some houses.
Good
Thank
job,
you so
Mike.
much.
Thank you,
Thanks,
Mike.
everybody.
We appreciate you.
Thank you.
Thank you, Mike.